What's going on, y'all? Attorney Tom here. Welcome back to SPAMUARY, where I post a video every single day. And yes, it's still happening. Yesterday's video, January 6th, was delayed because YouTube flagged it because we did a react to Season 1, Episode 1 of Perry Mason, because one of y'all sent me the entire collection of Perry Mason because you were probably upset with how I ranked him in the fictional lawyer tier list. Nonetheless, in today's video, we are going to be reviewing the Dunkin Donuts lawsuit where a man is suing for $50,000 because a toilet exploded on him. Attorney Tom. Okay, so this is Paul Kerouac versus HZO Donuts DBA Dunkin Donuts. This is in the 9th Judicial District in Orange County, Florida. General allegations on or about January 6th, 2022. January 6th, a popular date. Plaintiff, who was lawfully on the premises of the defendant, sustained severe and long-term injuries following the explosion of a toilet in the men's room of the business owned by defendant. The explosion resulted in the defendant and the interior of the room itself being covered with debris, including human feces and urine. Following the explosion of the toilet, plaintiff emerged from the men's room and sought assistance from employees and managers of defendant's business to clean himself as he remained covered with human feces and urine emerging from the men's room at the defendant's business. Okay, so it's actually very important to include this little snippet in a premises liability case, and that is that the plaintiff was lawfully on the premises. Why is this important? Well, because if you are unlawfully on the premises, it is possible that the defendants owe you a lower duty of care. But because he was lawfully on the premises, he was a patron of the restaurant, he was owed the highest duty of care. Plaintiff was informed by defendant's employees that they were aware of the problem with the toilet, as prior incidents with the toilet had occurred. It's also very important because that establishes notice. This was a known hazard. Plaintiff requires mental health care and counseling as a direct result of trauma experience in the restroom at a defendant's business from the continuing trauma following the event. So right from the beginning, we're told that there's likely little to no physical harm of the plaintiff. Otherwise, they probably would have included it in the introduction, meaning he probably didn't go to the hospital or to the emergency room or need corrective surgery, but he is seeking medical help for his trauma, his PTSD from the event, which the law does allow. It allows mental recovery for mental anguish, pain, and suffering. Now, who would ultimately decide what that mental anguish, pain, and suffering is worth? And that would ultimately be a jury. So without knowing any more of the facts, we tried to reserve judgment. I don't take sponsors. The only thing I ask is that if you need a lawyer, contact my team for a free consultation. While most people know me as a catastrophic personal injury lawyer, I'm actually a partner at 2 law firms that handle way more than just catastrophic injury. If you were the victim of securities fraud, received a notification that your info was included in a data breach, developed cancer as a result of a bad drug or toxic exposure, and many other situations, we may be able to help. It's important you talk to a lawyer right away to understand your options. If your case is not the best fit with us, we can help you find a great lawyer by using our national network of attorneys. Please click the link down below for a free consultation. So count 1 is negligence. Negligence means what would a reasonably prudent person in the same or similar circumstance do? Here, this would be a business. What would a reasonably prudent business in the same or similar circumstance as this Dunkin Donuts do with this potential hazard? As you can see here, we're going back to the premises liability theory. It says, at all times material, the defendants had a duty to its invitees to warn its invitees, including plaintiff, of any known hazards or hazardous conditions, which the defendants knew or reasonably should have known through exercise of reasonable care. And of course, in the introduction, we're told that the employees knew of the problem. And remember, the plaintiff is an invitee because he was a patron of the store, and that gives him the highest level of protection. And if you watch my videos before, you know we've talked about negligence a bunch. Remember, there are 4 elements to negligence, and you need to prove them all in order to prevail on a negligence claim. Duty, breach, causation, damages. So what happens next in these complaints is that the lawyers go through each of those elements. So here, duty, right here. They breach the duty owed to plaintiff by committing one or more of the following omissions or commissions: negligently failing to maintain or adequately maintain the men's room toilet, negligently failing to adequately inspect the men's room toilet, to ascertain whether the toilet constituted a hazard, negligently failing to warn or adequately warn the plaintiff of the gander of the men's room toilet. So we have our duty because he was an invitee. We have our breach, which is alleged here. Next, we have the causation as a direct result of the defendant's breach or multiple breaches of its duties, obligations. Plaintiff, who's lawfully on the defendant's premises, plaintiff unwittingly became the victim of an exploding toilet and of the aftermath which followed. As a direct and proximate result of the negligence, and this is important because there are 2 types of causation, okay? There's cause and fact and proximate cause. So he's going through both. So as a direct and proximate cause of the negligence of the defendant, plaintiff suffered bodily injury and psychological damages resulting in pain and suffering, disability, permanent and significant emotional injury, mental anguish, loss of capacity, and enjoyment of life, expenses of medical care. And the injuries and damages are either permanent or continuing in nature. The plaintiff will suffer losses in the future. So they're requesting in excess of $50,000 plus prejudgment interest, post-judgment interest, and plaintiff's cost of the action. And that's it. That is a very short lawsuit. This might be the shortest lawsuit I've ever seen. 2.5 pages? Wow. But yeah, without knowing any more facts of how damaged he truly was, without hearing what his story is, his credibility, his mental anguish, pain, and suffering, I can't really know how much damage was caused. But I can tell you this: it doesn't necessarily offend me for them asking in excess of $50,000. That doesn't mean that they are going to get $50,000. It just means that there's probably setting the standard. They're probably requesting a jury trial. But for me, being covered in poop, I mean, I could definitely see you couldn't pay me $10,000, $20,000 to be covered in poop. I mean, that sounds absolutely terrible. So, I don't know. I'm not really offended by the lawsuit. I know that it's a funny headline, but what do you guys think? What do y'all think? Leave your comments down below. How much money would you give if you were covered in poop at a Dunkin Donuts? And like and subscribe. All right. Bye.